Hello from Star USA Training. Today is Tuesday, March 21st, and the topic is export controls, sanctions, and anti-boycott. We are recording this webinar. The slides, recording, and any other materials will be made available after the broadcast. If you're watching this on YouTube, there's a link in the description below to get a copy of the slides. If you've attended our webinars before, you know that we often start out with the caveat that we are not attorneys. That's not true of our fantastic presenters today. John Yormick has been practicing for more than 30 years and has a focus on international trade, including compliance, sanctions, anti-dumping, export controls, and customs. John would like you to know that he shaved today, and it's a real pity that our webinars are set up without video, and I can confirm he looks very nice. Aida Dismondy has a law firm that specializes in international trade and government contract, and the unique part of it is that it's focused on small and medium-sized businesses in aerospace and defense, while most law firms with that expertise tend to only serve very large clients. So we are very lucky to have them today. That's all of the intro that I have. I will let our guests take it away.
Good morning.
Aida, why don't you get us started? I'll simply say thank you to Star USA, Joe and Michael, for the opportunity to present today. I'm not sure that we'll say much that you don't already know. Joe shared with us the roster of attendees, and certainly it's an impressive list. Everyone, of course, has different roles, experience levels. For those with significant experience, bear with us as we go through some of the basics, but hopefully we'll have some nuggets of helpful information for you. We'll watch what we say because at least one of the attendees appears to be BIS OEE special agent. And if he has been able to join us today, perhaps we can get some insights through the chat from the special agent. In any event, without further ado, I will turn it over to Aida to get us started.
Thank you, John, and good morning to everyone. As John mentioned, we will cover some of the basics. So as the saying goes, we'll begin at the very beginning. We have to have a disclaimer because, well, we have malpractice insurance, right? But also more importantly, to inform you that the reason why we're here today is not to provide legal advice, but rather to inform and educate. As to the subject that we are going to cover, as mentioned, we will start at the very beginning, but not to details. We turn this into a one-on-one export controls and sanctions session, rather just cover the basics for some of you that are new to export controls and sanctions so that you can have a foundation as we move forward with the discussion. We will have a primary focus on China and Russia, and of course, the penalty regime for both OFAC and BIS, and more importantly, the due diligence and compliance expectations for both the agencies. So this is an overview of the government agencies that enforce export controls and sanctions in the United States. You can read the slides at your leisure, but we include it here so that you can have an understanding of how the US government is involved in the enforcement of sanctions and export controls.
Let me just quickly interrupt that. On that list, these are the main agencies. I always say that trade compliance in general is kind of like a contact sport, but certainly you want to limit the contact and the types of contact that you have with the regulators and law enforcement. You need to be particularly careful, as we all know, but especially in this era of, or I should say, atmosphere or background of enforcement that is, pretty much in the news on a weekly basis through speeches and announcements coming from the Department of Justice as well as other agencies. Minimize the contact is certainly always the goal.
That's a great point, John. Yes, limit the contact with the agencies. You just need to know them. However, the less contact, the better, right? Do the right thing. Now, let's go back to the basics. We have started this conversation with, let's take a look at the export controls. For those of you who are not familiar, with the export controls, the permanent statutory authority for the export controls regulation, and that is the Export Administration Regulation, is the Export Controls Reform Act of 2018. This became law in when, as part of the John McCain National Defense Authorization Act of fiscal year 2019. So basically what it did, it codified, not only became the permanent statutory authority for the EAR, the Export Administration Regulation, but also it codified all the best practices of written and unwritten best practices of the Bureau of Industry and Security, which is the agency that administers and enforces export controls. It also created two parts, the Export Controls Act of 2018 and the Anti-Boycott Act of 2018. And more importantly, what was new with the Export Controls Reform Act is Section 1758, or what is known now as 1758 technologies, which required the Bureau of Industry and Security to include and add export controls to emerging and foundational technologies that basically are essential to the national security of the United States. And speaking of the national security of the United States, if you are new to this, as I was some years ago, you may question, okay, why do we have export controls? Then the reason for the export controls is namely to protect the national security, the homeland security, and the economic security, as well as the cybersecurity of the United States. What does this entail? What does the EAR, what is subject to the controls? Well, the regulations control the export and re-export and in-country transfers of commercial items, dual-use items, and less sensitive military items to end users and destinations of concern. Now, I mentioned earlier that part of the Export Controls Reform Act was also the Anti-Boycott Act of 2018. Basically, what it covers is the foreign policy of the United States, and namely that we oppose any restrictive trades toward individuals, toward US companies and individuals that do business in the interstate and also foreign commerce of the United States that are engaged in that. If these restrictive trades are against nations that are friendly to the United States or against US persons. And by the same token, this translates into this, that US companies or US persons engaged in export should not be engaging in activities that will forward another nation's foreign policy. I like to keep things simple. So the way how I tend to simplify this is United States allows individuals and companies to do business throughout the world, with the exception of countries that we cannot do business with, where we have sanctions and we also have the export controls. In other words, where we have restricted, where our laws and regulations restrict the trade. However, we cannot advance another nation's foreign policy if that nation says to our companies, hey, you cannot do business with these guys. Pretty much in a very simple term, in plain English, that's what the anti-boycott covers. But even though I simplified it, it is very difficult when in practice, as far as the application of the anti-boycott, because when we're talking about actions and activities, what does it entail? I want to draw your attention from the previous slide, and that's okay, you don't have to go back to that slide, but I want to draw your attention that the anti-boycott regulations that are administered by the BIS, and specifically by the Office of Anti-Boycott Compliance, they are not country-specific, and they are not to be confused with the Section 999 of the Internal Revenue Code. So the Treasury maintains the list, which basically is the Arab League nations. And we're not going to go into those details for time effects, but not to be confused with that. When it comes to the BIS, the restrictions on the restrictive trades, BIS, the anti-boycott regulations, they are irrespective of origin or country of origin or country, right? So when you have a country that is just merely restricting trade on a specific US company, regardless, it doesn't have to be the Arab League, that is the anti-boycott regulations do cover that.
Excuse me, let me just jump in. Really what's the focus here is, I'm sure many of the attendees are aware and familiar with, it's really the Arab League boycott of Israel. That is, I believe, the only country in which the anti-boycott regulations are implicated. There was some question not too long ago with respect to, did it apply to, if I recall correctly, Turkey, because of some actions that were taken, and it never really materialized. And that question was never really specifically answered by the OAC. So it's really very much an Israel-focused issue. But that said, when discussing the countries, and it's not simply the countries in the Middle East that are unfriendly to Israel. You have to look beyond that to populations with large Muslim populations, and that would include countries like Bangladesh as well as Indonesia. So you need to be on your toes and have the antenna up when looking for the potential offensive language in agreements, letters of credit, etc., as Aida is going to describe here.
Thank you, John. And so yes to that. Now let's look at, as John was mentioning, to look at the letters of credit. So the activities specifically that are related to the prohibited activities, that is related to anti-boycott. Typically, it is if you are receiving a questionnaire that requires you to provide the information of employees in terms of their nationality, their race, sex, or religion, then that should be an antenna for you that, okay, this may be more that what meets the eyes. In that case, you have an obligation to report. Or if you see in their letters of credit language in the terms and conditions that points to anti-boycott, or you may just provide information about US companies in terms of their employee makeup, again, going to race or nationality. Or there may be situations where you are agreeing to participate in restrictive trade. So those are some examples. It's not a conclusive list, but something to be aware of, and more importantly, to be aware of your obligations should you come across a request for anti-boycott. You have an obligation to report any requests for anti-boycott. In the event that you do not report a request for anti-boycott, then you are in violation of the regulations. And speaking of violations, when a violation occurs, there is an obligation that you have to file, just like for export controls, you have to file a voluntary disclosure. Since we're talking about the violations, okay, what kind of violations? They vary in degrees. Last year, BIS published new guidance when it comes to the categories of violations, how these are categorized from the most severe to the less severe. Become familiar with them so that in case you find yourself in a position, then you can kind of gauge, as John was saying earlier, hopefully you don't have to make contact with the agencies, but should it come to that, then become familiar with those violations.
Let me just comment that there were no anti-boycott violations reported last year by the OAC. There were only 2 cases reported in 2021, one in January of that year, one in September. Many of these penalties involve logistics companies, forwarders, et cetera, some banks. So we don't want to give outsized attention to the regulations here, particularly in light of the developments with respect to China and Russia, which we know we have some advanced questions on and we're going to get to. But this is an area that can be easily overlooked. And I think perhaps on the next slide, we have some examples of language to be aware of and watch out for. I'll also quickly mention that when you have a question about whether certain language in a tender, in terms and conditions, in a contract, might be in violation of the anti-boycott regs, and therefore must be reported, contact the OAC. They are very helpful. And I've had a handful of instances where I was pretty convinced that the language that we were reviewing needed to be reported and that the transaction with the U.S. client could not go forward. And the OAC looks at things a little bit differently. And in those handful of instances, they came back and said, no, that language is fine, even though it seemed to run afoul of the OAC regulations. So with that, I will let you talk a little bit about some of these examples.
Thank you, John. I appreciate that. And those are very great points. The examples here, as John said, the focus of our conversation will lead to China and Russia. But for our purposes, what to keep in mind, so what the examples here as a result of them, as you can see, they're quite convoluted. It's a convoluted language. So think of it as if you're deciphering code, which means that from your end, from a practical perspective, when you're reading any of the materials that are included, documents that are included in your transaction, it is crucial that you pay attention to the language. And perfect example that John shared, when you're looking at the language, go to the OAC and ask for help. With that, I think, John, you will take it on from here. Thank you.
On the sanctions, it's always interesting when trade controls, tariffs, sanctions begin to hit the mainstream media on a weekly, if not daily basis. And that's certainly been the age we live in the past handful of years now, whether it's 301 duties, 232 tariffs, et cetera. And now, of course, in this past year, 13 months now, Russia-focused sanctions. So again, some of the quick legal references here. The Trading Enemy Act dates back to much earlier times, and that still is the statute that is applicable to Cuba. Interesting note is that bipartisan group of senators in recent days introduced legislation that would actually look to ease the Cuba embargo. We'll see if that goes anywhere. But again, part of the current events and keeping up with current events in trade. AIPA amended the Trading with the Enemy Act because, as you see there in that sub-bullet under the TWEA, it was really a wartime statute giving the president authority to restrict trade during wartime. And AIPA came along and amended it so that the TWEA could be applied and enforced during times of peace. And it happens when the president declares a national emergency regarding a specific threat to national security, foreign policy, et cetera. There are other statutes that also form the foundation of many of the existing sanctions programs in the U.S., CATSA being one of them, with focus on Iran, Russia, and North Korea. That predates some of the more recent sanctions with respect to Russia in particular. Sergei Magnitsky. Rule of Law Accountability Act, as you see there, has been around for more than a decade, named after Magnitsky, who was an outspoken critic of the Kremlin and was essentially railroaded and prosecuted for alleged tax evasion, fraud, things of that nature. And this statute was passed to address human rights violations. And with the evidence of war crimes being committed in Ukraine in this past 13 months, we see more and more use of human rights sanctions being issued against some of the perpetrators that can be identified through the Magnitsky sanctions. All right, so the sanctions are codified in the Code of Federal Regulations, the CFR, Title 31, Sections 501 is where they start. Last count that I made, there's about 37 programs in effect, as most of you I'm sure know. Many are comprehensive programs, but many more are targeted. The big ones are the blacklist countries and now regions in Ukraine, Cuba, Iran, North Korea, Syria. Sudan was taken off of that list about a handful of years ago now, but you still see that often mentioned. That's a misnomer. So if you are looking at potential sales to Sudan, by and large, you do not have sanctions concerns as you once did. The Ukraine regions, since 2014, of course, have included Crimea. More recently, starting last year, in fact, just days before the invasion occurred, comprehensive sanctions were issued with respect to the Donetsk and Luhansk regions in the Donbass because of the recognition by Russia of those regions as being independent. And you'll see there that these comprehensive sanctions programs extend to imports. That's something that can be overlooked at times as well. Then you have some examples of countries where targeted sanctions apply. Venezuela, the targets are widespread, and it's somewhere of a hybrid, let's say, between a comprehensive program and targeted. There are very few opportunities for U.S. companies to do business in Venezuela. And then we have list-based sanctions, and that's usually dependent on a party, an entity, an individual, a vessel, or aircraft being added to the SDN list. Then we have secondary sanctions, and these are levied against non-U.S. persons. So foreign parties, very often foreign financial institutions that are found to be processing payments for SDNs that have had their assets blocked, their property blocked, narco traffickers, terrorists, etc. And those are concerned to foreign parties. And then we have the latest addition is the Russian harmful foreign activities sanctions. I think it's pronounced Rushhar, although that's probably incorrect once you hear it inside the Beltway or perhaps from some others who can help us in attendance today with the pronunciation of that acronym. And what you have to remember is that sanctions are very broad and they cover things like indirect. So the language is always direct and indirect, transactions and activities, evasion, conspiracy, and facilitation. So it's really very broad. And U.S. persons are prohibited unless otherwise authorized from engaging in even those indirect activities. Some of the authorizations come in the form of a general license. These tend to be broad, applicable to many U.S. persons having interests that are affected by sanctions. You see this often in a wind down license to divest from investments, to sell off property. Once sanctions go into place, there are oftentimes very specific conditions in every instance, and sometimes reporting requirements as well. The reporting requirements, for example, came when there was a loosening of Burma sanctions some years ago now, where certain transactions involving, if I recall correctly, an aggregate amount of over $100,000 had to be reported to OFAC, the Office of Foreign Asset Controls, which administers and enforces sanctions. And then there are specific licenses, and these are reviewed by OFAC and approved on a case-by-case basis. These are for specific transactions, do not fall within an authorization in a general license. You have to wait many weeks, sometimes months, for an OFAC license to be issued, for a specific license to be issued. And you really have to put everything on a silver platter, including the banks that will be involved in the payment. There has to be vetting of all the parties to the transaction. You have to have a lot of detail in the license application in order for it to potentially be successful. Hopefully, most people are familiar with OFAC's 50% rule, and this is focused on ownership. And essentially what this rule states is that if a party is on the SDN list and it has an ownership interest, and you see there direct or indirect, and that in the aggregate is 50% or more in another company, in another entity, that other entity must also be considered blocked or sanctioned. And I didn't say that very artfully, so let me see if I could say it again. So if you have one or more SDN parties and they collectively own directly or indirectly 50% or more of another entity, that second entity is considered to be blocked or sanctioned. It does not have to be listed on the SDN list, but by operation of law, OFAC considers that other party to also be sanctioned, and therefore U.S. persons are going to be prohibited from activities with that other party. Back in 2014, OFAC issued updated guidance on the 50% rule after Crimea, Ukraine-related Crimea sanctions went into effect. There have been some more recent reminders of that as well. But again, it's focused on ownership, not control. There's the reference to the guidance. For those who are not familiar with the SDN list, you can find it there on the OFAC search tool. I'm sure, and judging from many of the companies attending today, I'm sure that many use subscription-based services that screen for not just the SDN list, but global lists, including all US lists. But there is a specific search feature on OFAC's website as well that can be reviewed. And you see there the third sub-bullet under the 50% rule that, again, in August 2020, there was a reminder, so to speak, from OFAC that the 50% rule addresses ownership, not control. Here's a couple of examples for those not familiar of an SDN list, one from China, another from Russia. The one from China, you see there brackets at the end. It's for non-proliferation, weapons of mass destruction, as well as Iran sanctions, IFSR. And then, of course, you have Russia sanctions applicable to Kazan Helicopter Company for rather obvious reasons. This entity was added to the SDN list last year.
So if a BIS exemption came in and was received for EAR 99 items going to Cuba, do you still have to get a license from OFAC?
Generally, no, because between the agencies, they have kind of divvied up the jurisdiction so that, your EAR 99 item, and usually you need a CCATS on that. And it's, I believe it's been a little while since I've looked at it, but I believe there's a general license depending on the scenario. But by and large, the agencies with respect to Cuba have kind of divvied up the jurisdiction.
Can U.S. companies sell EAR 99 items to Russia or Venezuela non-restricted parties? Or do you have to get a license from OFAC because of the banking restrictions?
So the banking restrictions really come into play on the commercial side, let's say. What I have found, and I do have clients that do still sell into Russia on a limited basis, not so much Venezuela, although a little bit. But with respect to the Russia banking sanctions, by now, most Russian companies have opened up bank accounts either outside of the country or with a bank that is not subject to sanctions, either SWIFT or specific U.S. sanctions. My advice is always to talk with your bank in advance of receiving any payments or sending any payment for that matter. When a Venezuelan or particularly a Russian bank is involved, the banks are hypersensitive to sanctions because so many of them have paid dearly into the billions for violations over the years. And they will stop payments even though the payment is legitimate. So take advanced steps. You have a banking relationship manager, someone at the company does, your controller, CFO, etc. So make sure that you give a heads up to the bank before the payment from a party in Russia or Ukraine, for that matter, or any of the other countries where the comprehensive sanctions apply. That's the practical approach I always preach.
So we are going to continue with the list now from an export controls perspective, specifically as it relates to China and Russia. As some of you may be aware, in 2020, the BIS issued a list, broadened the rule for military end use items and also issued a list of military end users. Let's start first with the definition of the military end use. The military end use includes any US commodity, technology, or software that will contribute or support the operations, installation, maintenance, repair, overhaul, refurbishing, development or production of military items. So not only use, production and development, but all of these individual elements when it comes to a military end use. And as far as a military end user, are any entities that support or that are engaged in the actions or functions intended to support military end uses. So that's broadly the definition, but what is included in the list, the military end user list? Initially, we had military end users from China, Russia, and Venezuela. Ever since some of the entities from Russia and Venezuela have moved into the entity list. Crucial here to remember from a practical perspective is that now we need furthermore due diligence when it comes to assessing military end users, and especially in light of the blending or the blurred lines in China between military entities and civil entities. We have had some examples in the university space where the lines become blurry as to what's supporting who. Further due diligence, do not rely only on the restricted party screening or just the mere SDN lists when it comes to the military end users and military end use. And more importantly, when exporting a license requirements aside, keep in mind that you cannot export to a military end user if you have knowledge or even awareness that your items will be sent for military end use or military end user. John, will you add anything here as it relates to military end users and military end use?
Well, I'm first going to add that fourth bullet down, subpoint. This is taken directly from the Federal Register notice. And notice it says the expansion of the definitions will require, not it might, it would be a good idea, it would be a best practice, require increased diligence with respect to evaluations of end users in China. That is an important point not to be overlooked. And again, it's not going to be sufficient to do your restricted party screening and leave it at that. When you are selling into China, you must do open source due diligence. How much is done is going to depend on what the risk assessment looks like, your company, its resources to do the due diligence, etc. You need to be able to sleep well at night, of course, knowing that, okay, we didn't find anything, because really you're trying to prove a negative. No, this party is not a military end user that is supporting the PLA, for example. So doing that due diligence and documenting, because every regulator, every law enforcement officer from the federal government, no matter what the agency, they're all from Missouri. If it's not documented, it didn't happen. So doing your due diligence and having that documented is absolutely critical to answering any questions that might arise.
Thank you, John. Those are great points, as always. Let's focus a little bit on Russia and Belarus. As you know, even with the onset of the Ukrainian war, BIS issued sanctions on industry sectors, specifically related to Russia and Belarus. As of recently, more items have been added to the industry sector sanctions, and more importantly, when it comes to, initially there was a Schedule B items that were also subject to licensing requirements if they were headed to Russia or Belarus. Now, with the new changes, the Schedule B is no longer applicable when it comes to the license requirements. That will happen at the 6-digit level, meaning that the harmonized tariff schedule of the 6-digit code is the code that will be applied for the items that require a license. And in the event that someone says, okay, well, I'm just going to classify at the 8 or 10 digits, just somebody may have the idea that they may want to evade the license requirements. If the 6-digit code is similar, for that 8 to 10 digit is similar to the HTS 6-digit code, then a license is required. When it comes to license requirements, they're also for all items subject to the AR based on the, also for Crimea. And if they're headed to the Donetsk People's Republic and also Luhansk, forgive me for mispronouncing the names, People's Republic, unless they are for food and humanitarian reasons. So a license is required for all of them. Going back to the list as it applies to most countries, but especially to China. John, are you going to say something here?
I'm only going to say that I think everyone is probably familiar with the entity list.
Yes.
It has been significantly expanded in not just the recent year or two, but for several years now. It's hundreds of entries. Chiefly responsible for large expansion was Huawei and all of its global subsidiaries. Now we have Hong Kong included under China listings, and certainly dozens and dozens, if not hundreds, of Russian and Belarusian parties. The UVL is a bit of a different type of list because there's not a license requirement, but there is a documentation requirement. And you need a UVL statement, and the requirements for that statement are set forth in the Reg 744-15B. So if you don't have a UVL statement at the ready, you can put that together following the regulation. And then we see the fairly recent development last October with the regs being amended, that where there's sustained lack of cooperation by a host government authority that is squarely focused on MOFCOM in China, who has to approve all end-use visits and end-use check visits by BIS or embassy personnel. If there's a lack of cooperation over probably a 90-day period is the rule of thumb, those parties will be moved from the UVL to the entity list, so a license requirement will be necessary. So there's a non-SDN list specific to Chinese military industrial complex companies. This is really probably not one that most folks on the webinar have to be concerned about because it involves investments. So unless you're a bank, a hedge fund company, investment firm, you're really not very concerned here. You can still do business with these parties. Sometimes they are also appearing like CNOC on the entity list. So you have to follow the licensing requirements there. Then the sectoral sanctions identification list, that's been around since 2014, directives 1 through 4. I think more recently, we have a new sector designation in Russia, determination, I should say, and that's metals and mining just a few weeks ago. That does not mean that all parties in Russia in the metals and mining sectors are subject to sanctions, simply that OFAC can now designate those parties in those sectors. So if you are doing business in those sectors, and my guess would be a company like John Deere may have been selling into those sectors, you need to pay attention, because at any moment you may be dealing with an SDN and have to cancel the sale, because typically there's not much, if any, savings clause here. And then there's just quick reference to penalty last year involving, it was the first penalty involving one of the directives under the sectoral sanctions list. All right, we talked a fair amount about Russia. You see some of these prohibitions are very broad. Again, that last bullet talking about approving, financing, facilitating, etc., when a foreign person transaction is involved. So that means that U.S. parent companies, U.S. sister companies, U.S. parties to JVs, foreign JVs cannot be involved. Managers, directors, etc., cannot be involved in those transactions. For example, if it's a JV or subsidiary in China, in India, in Mexico, Brazil, other countries that have not imposed sanctions on Russia, because that decision-making could run afoul of Executive Order 14066 and be considered facilitating or approving those transactions of foreign parties. So you really have to wall off U.S. persons, entities, and individuals from those types of transactions. We'll make quick order of the penalties. The OFAC and BIS penalty regimes are very similar now and have been for several years now. I'm trying to think, about 6-7 years maybe, since BIS essentially adopted the OFAC penalty matrix and the approach to egregious versus non-egregious penalties and the applicable schedule penalty amounts, which are based on the transaction values. We have a continuing escalation in the maximum penalty amount, which currently sits at $356,000 plus for an IEPA violation. This is where most of the penalty violations occur. There's a brief outline of pre-penalty notice. You have an opportunity to respond to that and basically tell OFAC or BIS, as the case might be, okay, we're going to respond. We are looking at settling this penalty case that is being proposed, essentially, as the pre-penalty notice. Let's try and get this taken care of. You're likely going to be asked to enter into a statute of limitations waiver in consideration of that settlement opportunity. And then don't expect much in the way of negotiations, but certainly you will have the opportunity to raise mitigation factors, as well as, try and look at the amount of money that ultimately may be paid should there be a monetary penalty assessed. In most instances, that would be the scenario. Trying to negotiate down to a warning letter is possible, but not probable once the PPN has been issued. At least that's been my experience. There's penalty matrix from the OFAC penalty regs. You see there that there's over on the left-hand side, voluntary disclosure. So there's essentially a 50% credit given when a voluntary disclosure is submitted with respect to the statutory max being cut in half. And then you can potentially work down from that amount based on mitigating factors that are available. Voluntary self-disclosure does not mean that there will not be a monetary penalty assessed. simply that you're going to be credited in a significant way and that penalty dollar amount would be reduced. Here are some of the factors that are considered. What I want to point out is that having a written compliance program is not a mitigation factor. It's a general factor, and it's considered really as a necessity nowadays. If you do not have a compliance program in place, it can potentially be an aggravating factor, especially given the size and markets of certain companies. Now, we're running up against the time limit here, Joe, and I know that there are questions. So unfortunately, we geeked out a little bit and told some stories and got passionate about things, and that took time, for which I apologize. But Joe, I think we should probably wrap it up here. If there are questions, they can be emailed to us if we can't get to them right now.
That sounds great. I'm going to run through the rest of your slides really fast so attendees can see what's available. There's a slide on responses to apparent violations, some guidance from BIS.
Yeah, this is just the penalty regime from the BIS side. So
Great.
Very similar to OFAC.
And then some compliance resources. These are fantastic resources, Department of Justice, BIS, and OFAC.
I just want to point out the Justice Department guidance is from the criminal division. However, it's helpful to read and understand where the government is coming from and beefing up your compliance as necessary to fully insulate it.
Beautiful. A little bit on the enforcement environment, and then last slide with John and Aida's details. Do you want to take a couple of questions really quickly and then wrap up?
Let's take some questions.
Okay. The first one is, it's a US company. They have a distributor in Russia that they had been doing business with for a long period of time and stopped doing business in 2022. The US company has an account that the Russian company owes a balance on, and they would like to receive payment. Their payments to other US vendors have been stopped, and the Russian company is suggesting to route the payment through entities in Kazakhstan or the EU. Can we do that, or do those creative payment suggestions mean they're recommending evasion?
I haven't seen anything that it's considered to be evasion. The banking sanctions are limited in scope to certain Russian banks. What I have seen in the past year is that many Russian companies have opened accounts at non-sanctioned banks, either inside or outside of Russia. Going back to what I talked about earlier, discuss with your bank first any incoming payments. That's going to be practical side of things as important as confirming that there are no sanctions against the newly selected bank, let's say. If monies are owed, if the source of funds is coming from a non-sanctioned party and from a non-sanctioned bank, then that should be fine.
Excellent, thank you. What are some best practices for verifying that our customers are complying with our requirements that they not sell to Russia, Belarus, or other sanctioned countries?
Audit them. Do your own end use check, so to speak. In the law, in contracts, our first year of law school, we learn about reasonable reliance in a contract context. The end use statement, the certification that you obtain, BIS 711, if you use that, it doesn't necessarily mean it's worth the paper it's written on if the source of the information is not reliable. Trust but verify is what President Reagan used to say, and that was about the Russians. So you want to do that, especially in light of several news reports and many government announcements with respect to evasion, transshipment, diversion, and you need to ask and you need to check into that. You need some verification.
All right, fantastic. Thank you both so much, John and Aida, and thank you, attendees.
If you have any additional questions, please email us at train@starusa.org.
Have a great day.